We're live.
Okay, great. All right, welcome everyone. Today is Thursday, March 25th, 2021. Welcome to the Judicial Proceedings Committee. We have 6 bills on the docket today. We'll start off with Senate Bill 953, then Senate Bill 955, then we'll go directly to the chairman, House Bill 180, then we'll go to House Bill 50, House Bill 781, and House Bill 839. So with that, we'll start off with Senator Augustine with Senate Bill 953. Welcome, the floor is yours.
Thank you, Chair Smith, members of the committee, and I appreciate the indulgence of letting me go first right now. Members of the committee, Senator Malcolm Augustine here to talk about Senate Bill 953. Senate Bill 953 is a task force to work on the communications around domestic terrorism. Colleagues, the Battle of Bladensburg was fought in Maryland, August 24th, 1814. British victory left DC really open to British invasion. Tricked by feints and everything else, they attacked from the northeast of Washington at Bladensburg. Embarrassing defeat led to the burning of our nation's capital and other parts of the entire city. Bladensburg is a town that is next door to the town where I live and where I represent. We live 5 miles from the US Capitol. The insurrection at the Capitol on January 6th obviously hits particularly close to home for us. We have a unique perspective based on our proximity and a number of our neighbors who work in the complex in and around it. But we also have it because the folks who were involved in this stayed in hotels in our district where we live. And we also had where folks were just concerned at our borders. They were worried, nervous. Some folks went to check on those places while this was all going on. And since then, we received a letter from the city of Hyattsville asking for support for looking at this situation and trying to make sure that we are better prepared the next time. They had a set of recommendations that they asked about, but one of the things that they did talk about was communication of the threats. And I thought that that's what this task force is there to do, is to bring people together for us to get a better sense of how to better communicate these threats and make sure that the public is informed of what's going on. We've put this in MEMA, and I think that the reason it should go in MEMA already has a complex coordinated terrorist attack program through the Department of Homeland Security, where they're doing the strategic and regional training exercises, planning, operational coordination, and operational communication. I just think that this is a place where we bring these stakeholder groups together and with the very specific task of working on this communication and to the public. That's the bill. I'm asking for you all's support, the Senate Bill 953.
Excellent. Thank you very much, Senator Augustine. And with that, that'll conclude the hearing for Senate Bill 953. We'll now move on to Senator Eckert. Is Eckert Senator? No. She's not here. Okay, then let's move on to the chairman. If is Delegate Clippinger, there we go, Mr. Chairman. All right, let's do this. So we'll go to House Bill 180 with Chairman Clippinger. The floor is yours.
Good afternoon, committee. Thank you very much, Mr. Chair. I appreciate you hearing House Bill 180, legislation related to juveniles who are engaging in sexting and their relationship with the law that we have on the books related to the possession of child pornography. I'm sorry, I heard somebody else jump in. Let me go again here. The House and the Judiciary Committee has worked pretty extensively on this issue over the last couple of years with advocates on every side of the issue. And in fact, over this last year, Delegate Emily Shetty worked with advocates on every side of the issue to move forward legislation that you have before you today. These pieces of legislation are in relation to the case from Charles County, in race SK, and they've kind of spun out from that case and have sought to take a balanced approach to how we deal with situations related to teenagers who are engaged in sexting. And there are a lot of issues that need to be kind of put in balance here. There's a desire, I think, to protect teens from the risks of sexting, especially long-term. Things that end up on the internet have ways of never, ever going away. There's no question in the legislature that we treat issues related to the possession of child pornography as being very, very important. I know that we all agree that that is a very serious crime, but we also acknowledge that there are teenagers who are engaged, teenagers in healthy relationships for whom this is becoming a common practice. And I think that no one believes that that teenagers should be put on the sex registry or are detained for possession of images where there's been consent, where there has been whether the two people are close in age. So that's really the solution that we've carved out here in 180. And again, I want to recognize Delegate Shetty's work here. And it's a solution that you'll hear from the Office of the Public Defender, and I do acknowledge their concerns here as well. But what HB 180 does is it carves out the sending and receiving of most sexual images between young couples who are close in age from the statutes related to the possession and distribution of child pornography. It continues to give courts the discretion to address cases involving extraordinary circumstances while creating a separate alternative response for teenagers involved in sexting. And it does that by carefully defining sexting and requiring the court to consider whether the case involves sexting, and then specifying what the court can do if the case does in fact involve sexting. I can get into a little bit more of the details and the alternative response that we're proposing here with the bill. So I'm happy, Mr. Chair, just to take some questions and try to address that if you'd like, or if people don't have questions, that's perfectly fine too. But I'm happy to do whatever is easiest for you.
Excellent. Well, how about this? Let's do the panelists first, and then we'll add questions at the end. So I have two proponents and then two folks signed up in opposition. We'll start off with the proponents, with Ms. Jordan as first. So Ms. Jordan, the floor is yours.
Thank you, Mr. Chairman, members of the committee. Thank you, Chairman Klippender, for this legislation. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We urge a favorable report on House Bill 180. As you've heard, this involves sexting, and there are many competing concerns. I think to help understand the policy issues involved, consider the following. In Maryland, it is not against the law to have sex with a young person, as long as the age difference between the people involved is less than 4 years. So for example, a 16-year-old boy can have sex with a 14-year-old girl. In fact, the 16-year-old boy can have sex with 20 14-year-old boys. The difference between sex and sexting is that there is a third element involved. It is not just the sex between the young people and the attendant risks and the personal harm between those two. There is now also an image that is created. That image is child porn that can then be used throughout time, throughout the world, and can exist and produces real and lasting risk to those teenagers. So going back to our hypothetical, that 16-year-old boy having sex with the 20 14-year-old girls could also have 20 pictures of 20 different naked girls. And those teenagers would be at risk of revenge porn, of sextortion, of sex trafficking, of negative impacts on employment or academic options, and more. And promises to keep those images private, we know they're not always met. And we know they could give rise to other charges, but that's not going to change the fact that they would be up on the internet forever. So we have that on one hand. On the other hand, sexting happens and it is here to stay. And right now, the laws in the state of Maryland mean that those kids are either possessing child pornography, producing child pornography, or displaying obscene materials to minors. And so we don't know how many teenagers sexted, but a recent study said that 1 in 7 had admitted to sending one and 1 in 4 admitted to receiving them. So this is reality, and those kids are not sex offenders. We should have a response that balances these competing issues. So as the chairman said, this bill defines sexting. It's pictures of oneself or just the couple within the couple, so not the football team. It is teens within 4 years age difference, which is the same as the laws regarding sex. And it does not include situations where the child does not consent to the creation of the image or was coerced, threatened, or intimidated. There are then limits on the court. If it's sexting, the child cannot be placed in community detention absent extraordinary circumstances. The child may be ordered to participate in education, and the child, of course, may not be placed on the sex offender registry. So all of these things balance these competing concerns. I would respectfully suggest that there is no perfect solution to this one. Child pornography is unbelievably harmful, not only to the people involved, but to the community as a whole. Sexting is often not harmful at all to the teenagers involved. We need to figure out a way that balances these two competing concerns. House Bill 180 does an excellent job on doing this. And I just wanted to add, in addition to acknowledging Delegate Shetty and all of her help, that we also consulted with some of the pages and heard from them about their experience as teenagers. I appreciate the contributions of these young people. And with those comments, happy to answer questions and urge a favorable report on House Bill 180.
Thank you very much, Ms. Jordan. And next we'll move on to Mr. Potashnik. You're up next.
Good afternoon, Mr. Chairman, members of the committee. Gavin Potashnik, Deputy State's Attorney for Harford County. We are asking for your support in this important legislation. I do thank Chairman Clippinger for bringing this to the forefront and for thoughtfully looking through the problem. I also thank Delegate Shetty for picking up the ball and really crafting some language, which I think, as echoing what Ms. Jordan indicated, really balances the problem versus the solution. Mindful that the Department of Juvenile Services and the juvenile system is there to help. Law enforcement, in my interactions with them with respect to this particular issue, do not want to put all kids in front of the Department of Juvenile Services for what they call, and I hate to say this, ordinary sexting. Where they get concerned and where the state gets concerned is when the images are so out of control or crazy, there's too many of them, there is no choice but to forward to the Department of Juvenile Services because it's indicative of a big problem. I did receive the stats from the Department of Juvenile Services. You can see what the scope is with respect to child pornography. And I would note that in 2019, there were really only 43 cases that were forwarded to the State's Attorney's Office for prosecution. Out of those 43 cases, only 19 were placed on probation. The vast majority of these cases are dealt with either at the intake level or before they even get to disposition. So recognizing that the problem isn't really so as large, nonetheless, there needs to be a creation of a disposition that would really help these youth. And this is a good kind of balance with that because it provides a mitigating factor for the court to consider when they're fashioning a remedy. Nobody wants to put ordinary type of sexting into an institution. Nobody really wants to put those kids on disposition that has a detention aspect to it. However, when the problem does exist that a child does need services because of an issue that relates to this particular topic, then I think it's important for room to that to happen. This provides that discretion in a meaningful way and provides a mechanism by which the court can actually holistically look at this and decide whether there is a problem for them to deal with or whether there isn't. So I would submit to the committee that the issue has many different layers before it even gets to the court, but this is a good way for the court then to decide what the actual issue is and how they can best deal with it, which is completely within the confines of the juvenile system. So I'd ask for the support from this committee and I'm here for any questions. Thank you so much.
Excellent. Thank you very much, Mr. Potashnik. So we'll now switch over to the opposition panel. So we have Mr. Schoelenberger, you're up first, and we'll go on to Ms. Gross.
Thank you, Mr. Chairman, members of the committee. I candidly have to tell you, I am really struggling here with this. I communicated with Chairman Clippinger over the weekend. I just talked to Mr. Potashnik. I recognize that that this is an issue that we need to deal with because In Re SK brought a lot of people to the table, and I've testified about this bill before. I certainly preferred the original, but Chairman Clippinger educated me and said, this is what we're going to get. And so I drafted testimony this weekend that said support. Then I wrote support with amendments, and then I submitted opposed. And now I'm not sure what I'm doing. But let me just point out my biggest problem. And I think it's just this one thing. So the definition is good. We need that. That is great. The places where you say, don't send them to a juvenile facility, don't basically incarcerate them, that is great. Absolutely agree with Mr. Potashnik that the whole key is this child needs services depending on which side of this thing they are. So how do we get them into court? And this is a mechanism to do that. The problem is this: sexting, number 2, does not include conduct described in paragraph 1, your definition, if, and here's the one I'm having trouble with, the sender is more than 4 years older than the recipients. So a 17-year-old boy sends pornography to a 12-year-old girl, and now that's not wrong? Isn't that the very thing we're trying to fix? So I am getting so close to being in favor of this. I'm like 3/4 or more there. It's just, I understand why we went after that part of the statute, because that's what we use in the sex offense statute, but we use 4 or more years older. I mean, in my mind, a 12-year-old sends to a 12-year-old is less bad than a 17-year-old sending to a 12-year-old. So if somebody could correct me if I'm reading this wrong, please do so. But it does say, except if the sender is more than 4 years older than the recipient. That doesn't solve the 17 and 12-year-old problem. And I hope someone asks Ms. Jordan, who I respect, Mr. Potashnik, who I respect, that scenario, because I hope they tell me I'm wrong and we can get this over with. I know that's the weirdest testimony I've ever given in Annapolis, but that's it.
Excellent. Thank you very much.
And you're all smiling.
All right. We'll go to Office of Public Defender, Ms. Gross. You're up next.
Good afternoon, Mr. Chairman and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Charles County, where I represent youth and juvenile and adult court. I was the attorney who represented SK, that teenager from Charles County who was charged with distribution of child pornography for sending a video of herself. I appreciate the efforts, but I'm concerned, and the others that I've spoken with are concerned, that this bill won't fix the problems that case highlighted or the goals that were discussed today. Instead, the concern is that this legislation would endorse the problematic status quo. And instead, in a legislative session where we're focused on reducing the number of youth involved in the juvenile justice system, this bill would increase the criminalization of common adolescent behavior. The first problem we have is that this bill still treats sexting as child pornography and only makes the fact that it was consensual sexting a mitigating factor to be considered at the sentencing stage, which means that an adolescent can be charged, prosecuted, and have a trial before they can even raise the mitigating factor that the underlying behavior was consensual sexting. This leaves too much to the discretion of police, prosecutors, and judges, which is a problem because that case from Charles County in Ray SK was the result of an abuse of discretion. It's the result of a police officer at school abusing trust and discretion to charge a teenager with distribution of child pornography for sending a video of herself engaged in consensual sexual behavior. And it's the result of a prosecutor and court abusing discretion in prosecuting and convicting that teenager. Second, we're concerned that this bill codifies the harms that it's meant to prevent. We're concerned that a teenager whose private photo is posted publicly, like actually happened in SK, might be scared to approach a trusted adult because they could be prosecuted for initially taking the photo, like SK was. We're concerned because the bill, while limiting community detention, allows punitive measures like detention and placement, which can lead to exploitation and blackmail and increase the potential for self-harm. Although some changes were made in the House that were discussed, those changes didn't include the voices of youth affected by this legislation. I have some of their thoughts I'd be happy to share, and I know that they sent written testimony to members of the committee. And instead, those changes removed the affirmative defense, which means forced or coerced sending of sexual images is still included in child pornography prosecution. And the changes also excluded too many instances of consensual sexual sexting from even the mitigating factor. We urge the committee to promote legislation that protects instead of punishes teenagers. This isn't about condoning sexting, but instead understanding that as many as 27%, thank you, I'm finishing up. 27% of teenagers have sent or received a sext. We want to make sure they're safe. We want to make sure that they know that there are resources available. We have 3 solutions that I would offer. I know my time is up, so I'm happy to offer those solutions if asked. And I'm available for questions from the committee.
So thank you very much. With that, that ends the testimony for House Bill 180. We'll now turn to the committee for questions. Seeing none, thank you all very much. Thank you, Mr. Chairman. And with that, that'll conclude the hearing for House Bill 180. We'll now move on to, I see that Senator Eckert is here. If you're ready to go, Senator, we'll go on to Senate Bill 955.
I am. Thank you very much. Mr. Chair, Mr. Vice Chair, and members of Judicial Proceedings, I'm here today to present to you for the first time Senate Bill 9. Am I still on mute?
We can hear you. You're good.
Oh, I'm sorry. Okay, I just have a little thing on my screen. Sorry about that. Anyway, this is Senate Bill 955, the Local Government Tort Claims Act for the Cambridge Waterfront Development, Inc. Mr. Chair, you know, you've been to Cambridge. Cambridge is on the move. There's a lot of activity there on the waterfront as we relocate our hospital system out on Route 50. And we've worked with the Sailwinds Group probably since the early 90s to develop the waterfront. And it's been a long time coming to get the county and the city to agree and work together. So the Cambridge Waterfront Development, Inc. was established actually in 2018 by the Cambridge City Council and by the Dorchester County Council. And since that time, this CWDI has fostered community partnerships and relationships while planning for a mixed use redevelopment along the Cambridge waterfront. So Senate Bill 955 alters the Local Government Torts Claim Act to include CWDI under the local government, since this has been a product and creation of 2 different governments. The bill will provide protections through the act similar to the ones afforded to other economic development entities across the state. And as Dorchester County and Cambridge continue to grow and redevelop, CWDI will continue to be an important player. Thanks so much for your consideration. I respectfully ask a favorable report and passage of Senate Bill 955. And I apologize for bringing this into you late, but it was brought to me late, and that's why we're here. And I just need to get it across the street and pass so we can proceed with a lot of activity and revenues that we've already applied for. Thank you very much.
Excellent. Thank you very much, Senator, and we'll do our level best. So thank you very much, and it was great chatting with you after the floor today. So thank you.
Oh, great. Thanks.
All right. With that, that'll conclude the hearing for Senate Bill 955. We'll now move on to Delegate Stewart with House Bill 50. Delegate Stewart, welcome.
Thank you very much, Mr. Chair. So Chairman Smith, Vice Chair Waldstreicher, members of the committee, good afternoon. For the record, I'm Delegate Vaughn Stewart. This is HB 50. So your committee has obviously heard many controversial bills this session, but I have some good news. I do not think that HB 50 falls into that category. This bill was drafted in response to a number of complaints I heard from constituents and from some other Maryland residents outside my district about basically particularly abusive landlords. The provisions in the bill will therefore not apply to the vast majority of landlords. And that's why MMHA, AOBA, and the builders came in favorable or favorable with amendments that have since been adopted on the House side. So there's no institutional opposition to the bill. And an identical version of this bill passed the House 131-0 last year. It also passed the House this year on a bipartisan fashion, but there were more no votes this year for some reason. So the bill, HB 50, really does 4 simple things. First, it extends early lease termination protections that currently exist for survivors of sexual assault and domestic violence to survivors of stalking. And then it allows survivors of sexual assault, domestic violence, and stalking to demonstrate their survivor status with a statement from a therapist or a social worker. Right now, they are required to get a peace order in order to prove their survivor status and be eligible for early lease termination. Second, the bill requires some degree of transparency from landlords that use a ratio utility billing system. So they basically would have to use how they're calculating, they'd have to disclose how they're calculating that if a tenant asks. Third, the bill requires landlords who choose to withhold part of a part or all of a security deposit to provide tenants with supporting documentation, basically show the receipts for what they spent that money on. And then fourth, the bill grants tenants the ability to use community spaces, common areas within the building if they're used by other groups. That tenants can use that space for free once a month for the purpose of tenants association meetings. And so in conclusion, I think most landlords treat their tenants fairly and with respect, but some see this power imbalance as an opportunity to exploit vulnerable Marylanders. And so this bill provides some very, very basic protections for a minority of situations. And with that, I urge a favorable report.
Excellent. Thank you very much, Delegate Stewart. We have one question from Senator Carter, it seems. Let's see. Senator Carter, you're up.
Thank you, Mr. Chair. You'll be happy to know I don't have a question. I just want to say thank you for bringing the bill. I think it's a great bill, and if I could, I'd move favorable right now. I also want to mention that there's a Senate version of the bill, but it's still stuck in rules, sponsored by our own Senator Michael Jackson and myself. And so I'm sure that if we're postured to pass this bill, we'd also consider the Senate bill as well. Thank you so much.
Yeah, thank you, Senator Carter. And you're right, I was remiss not to give both you and Senator Jackson a shout out for all of your help with this bill. And I share your views. I appreciate it.
Excellent. Thank you very much, Delegate Stewart. Well, hey, we'll talk to the chair rules over there and we'll get both bills moving. So let's rock and roll. All right. Thank you very much, Delegate, and we'll see you soon. And with that, that'll conclude the hearing for House Bill 50. We'll now move on to Delegate Dumais. Is Vice Chair Dumais here? Is she still here? Do not see her here. Okay, we'll now move on then. We'll go, I see Delegate Chi is here. So we'll go with House Bill 839.
All right.
Here we go.
Thank you, Mr. Chair. Great to be back to JPR again. This is a super simple bill, HB 839. Essentially, all it does is to codify the existing practice of the State Department of Assessment and Taxation by extending a one-year grace period to Maryland businesses that fail to file their annual report, so that they won't be automatically forfeited that same year. And that's basically all it does. We basically discovered this year that it's not in our statute. It is a current practice and it's serving Maryland businesses well. I think we can all agree at this point, there is so much on the plate of our struggling small businesses, and whatever we can offer to help them to make sure they are in good standing is very helpful in their ability to continue to operate in our state, but also to be able to apply for grants and loans. So it was brought to our attention, to ECM's attention by the administration, and it passed the House unanimously. That's basically all it does, to offer registered Maryland businesses one-year extension if they fail to file with ESTED. Okay.
Excellent. Thank you very much, Delegate. And seeing no questions, that will be the end of the hearing for House Bill 839. Thank you very much, Delegate G. Now we have just one more bill, Delegate Dumais, but I don't see her here, so we'll move on. Senator Heddleman, my apologies. I see that I was texted and someone said that you had your hand up on a bill. I did not see your. Okay, got it. All right. And with that, that'll conclude our hearings for the day. We are now going to go on to our work group for police reform. So Council Jamie Lancaster is going to give us a kind of a walkthrough of what's in the House bill, what differs from what we did in our 9 bills. I'd like to do that down here in the committee room. It's 1:30. Let's say 2 o'clock. Do you want to do 2 o'clock? I think you can run through it in an hour or so. Sound good? Excellent. See you all soon.